Do you or your family member have a medical disability that prevents you from learning English? Let's talk about that today. My name is Audra Doyle, and I'm the owner and attorney of Doyle Law in Atlanta, Georgia. For those who are ready to apply for naturalization, you have to pass 3 tests. One is English reading, the second is English writing, and the third is a civics and history test also conducted in English. But some clients are unable to learn English, and today we're going to talk about whether you qualify for an exemption from this requirement. The form that needs to be completed by your doctor is Form N-648. And the doctor must show a clear connection. In immigration law, we call it a nexus, a clear connection between the effects of the disease, what the disease is doing to your mind or your body, and your ability to Learn English and to answer the questions on these tests. So for example, a case that will probably be approved is for an elderly applicant who has Alzheimer's disease or dementia. And the doctor can clearly show that those diseases are affecting her cognitive abilities, her ability to learn, and probably also her ability to communicate. Next, the type of case that is much harder to prove is if a client has physical disabilities or disabilities that don't necessarily affect their cognitive abilities. So if they have a heart condition, if they are going through cancer treatments, things like that, it may be harder to show that those issues affect their ability to learn. Age is not a good enough reason to be approved for a medical waiver of these tests. And the way that you can show that the disability really does affect learning abilities is to have the doctor write an extremely detailed explanation on the Form N-648. The explanation needs to list the diseases or the conditions that the person has, and they need to describe the effects, the severe effects, whether they're severe, whether they're mild, and whether the disease is progressing. All of those things, they need to clearly document that for the immigration officer. Now, the last thing I want to tell you may surprise you. The immigration officer can disagree with the doctor's opinion. They're not doctors down at immigration, but they do have the power to with the N-648 that was prepared by the doctor. Common reasons why they disagree are: number 1, the doctor was too vague. Number 2, the diagnosis happened long ago and the client seems to have recovered. And their own observations at the interview of whether they actually have this condition. So the officer does have the power to say, no, this is not strong enough, and they can ask you to go back to the doctor, get a better diagnosis and description, or they can say that the doctor is not their general care doctor and the medical diagnosis was simply made so that the person does not have to take the test. Those are things that really can happen. So if you want to be approved for this medical waiver, think about the idea that the doctor needs to be extremely detailed. And lastly, they need to show that connection between the disease or disability and that person's ability to learn English and to perform on these tests. I hope that this information is helpful to you, and thanks everyone. Have a great day.